This is the panel on fixing executive power. You know most of this cast of characters by now. I'll just introduce Ramon Buhler, who's the director of the Madison Coalition. And then we have Howell, who's at the University of Chicago, and Ruth Wedgwood, who's at Johns Hopkins. So Ramon, would you like to start us?
Sure. Well, thank you so much for the opportunity to be here. I was a lawyer for Congress for 14 years. I was actually Newt Gingrich's first committee counsel. And so I spent a good chunk of my career working on the opposite side of the spectrum from Senator Feingold, who accomplished one of the great modern miracles in the political process. He put together a bipartisan coalition of people and against the wishes of the leadership of both the House and the Senate, passed a bill. And it illustrates a point, and that is that the political process, when you give it a chance to work, actually does work if a majority of people want a result. And I'm concerned because I have seen a transformation in the political process in the last few years from the traditional mode of legislating, where you do things like what Senator Feingold did, from which I would call a democratic process, to what has increasingly become an undemocratic process. Increasingly now, if you want to change the law and you don't think you can put together a majority in the House and the Senate, you instruct your regulators to pick a law that was passed 50 years ago, issue a new set of regulations, and that becomes the law. And that radical transformation of what is essentially a legislative process, I think, undermines the very foundation of our democracy and the very foundation of rule of law. 800 years ago, we had a Magna Carta, and the principle was that the king doesn't make the law. But if a system exists under which the executive branch, directed by the president, can rewrite the law at will, no one is safe. You meet with a group of people and you say, when this meeting is over, some of you are going to leave as my friends, and some of you will not leave as my friends. And the implication is that you might want to be visited by regulators if you're not one of my friends. And if the president can fine-tune regulations to reward his or her friends and punish his or her enemies, we have ceded an enormous amount of power to one person and their appointees. And I don't think that most of us in this room want to see that happen. And so the amendment that I am proposing today is called the Regulation Freedom Amendment. It is very simple. It says that if a quarter of the House or the Senate object to a federal regulation, then a majority of both houses must approve it. And the principle, again, is, you can put it in a phrase, no regulation without representation, or you can more broadly state that regulations, like laws, should have the consent of the governed. Now, politically, you can say, and I have had fun asking politicians this question, sir, do you think that regulations ought to be dictated by unelected bureaucrats in Washington, or do you think they ought to be approved by elected representatives of the people? And I have discovered a certain reluctance by certain kinds of politicians to answer that question. And I think the reluctance is there because they understand that if they give the wrong answer, they're in trouble. And there's another way to phrase that question, and that is, if a regulation is going to take away somebody's property or limit someone's liberty, should members of Congress have the guts to cast a vote on it, or should it be done automatically without anybody having to cast a vote? And most of my conservative friends are generally in favor of curbing the authority of regulators, but some of you in the audience are progressives. And I ask, when the next terrorist attack comes and someone decides that your liberties are going to be taken away in the interest of public safety, do you want those liberties to be taken away and that privacy to be taken away by the dictates of a bureaucracy in Washington, or do you want those liberties to be taken away in a process that gives elected representatives of the people the ability to review and approve what's been done. And, you know, tyranny comes in many forms, but it is always justified by a crisis. And one of the protections we have in this country against tyranny is that the laws have to be approved in a legislative process, and it's sometimes messier and slower than we would like, but we've survived for 225 years because we've had a legislative process. And I think one of the questions that faces America right now is, are we going to continue that 225 years, or are we going to basically go to a new process where the laws are made by a group of, quote, experts or unelected bureaucrats, however you want to characterize them, that are not accountable to anybody except for the executive that appointed them, and particularly in a president's second term. And Obama, by the way, did not give the "I have a pen and I have a phone" speech until the beginning of his second term. He did not give it in October of 2012 with the election coming up. If you have a president in his second term, that president is never accountable to the voters again. And so do we want to give a president in his or her second term that kind of unlimited power? And I think that's the question. Now, there are going to be some people who think, well, who have objections. And I would characterize the objections in two ways. One, they're technical objections. Maybe there's a different way to word the amendment. Maybe there should be some exclusions. And I would point out that in the process that we're talking about, and this, by the way, is not a theoretical amendment, there are now 1,000 state legislators who support it. There are 24 state legislative chambers that have urged Congress to propose it. It's been unanimously endorsed by the Republican National Committee. It's in the Republican platform. Governor Pence was the first governor to endorse it. There are 7 governors and former governors who support it. And we think that there is a realistic chance that in the political environment of the next 3 years, that 2/3 of the states might be able to do what 2/3 of the states did when they persuaded Congress to propose the Bill of Rights, and more recently, what they did when they forced Congress to propose presidential term limits. In fact, 3 times in American history when 2/3 of the states have gotten together and Congress perceives that 2/3 of the states want the same kind of amendment, Congress has proposed the amendment. So we think this could actually happen because the public wants to see regulators accountable, and 2/3 of the states may, in fact, decide that they want to ask Congress to do this, and it is in the self-interest of many members of Congress not to become an advisory body. So it could happen. But the process is a legislative process. And so as this amendment goes into the legislative process, as I said to one person, I said, you know, when you put the cow into the meat grinder, the hope is at the end you get beef, not pork. And so we think that what we're doing is beginning the process of constitutional reform to curb the administrative state, and that in discussions like these, this product will be refined so that the final product that will, after all, have to get the approval of 2/3 of Congress, will be something that does end regulation without representation, and some of the technical problems will be solved. Some of you may not have technical problems at all. You may say, look, if Congress has to approve regulations, there will be no regulations, or there won't be enough. And I think the philosophical question is there a greater danger to the Republic of too many regulations and too much executive power and too much abuse of power? Or is our problem that 90,000 regulations is not enough and we need many, many more? And I think that's a legitimate argument. There are people who believe we need many, many more regulations, and requiring that Congress approve them is probably going to reduce the number of regulations. But I would also argue that in cases where we need regulation, where it's critical, that requiring that regulations be approved by Congress also creates an opportunity for the Russ Feingolds of the world to demand that Congress act, and to demand that critical problems that need regulation be addressed. And so this amendment cuts both ways. By making regulators and Congress accountable, I think we make the system more collaborative, there's more negotiation, but we also make it more responsive. And I guess I would close by saying that because this is not a theoretical proposal, it's a real one out there. I think 1,000 citizens around the country who get active and talk to their media and talk to their elected officials could have an enormous impact. And anybody who'd like to come up to me afterwards and give me their card or get my card, I want to talk to you, because I think the people in this room actually could make this happen. So thank you very much.
And Mary Ann Case will give us some comments.
Okay, so this is an area, everything concerned with this proposed amendment involves areas of laws I know virtually nothing about. And therefore, everything I say should be taken with that caveat. This is not what I do. I had just said this week, I took administrative law and Fed courts are the courses I can remember nothing about. So bearing that in mind, I will say, as I said to Ramon before lunch, when I first read this amendment, my reaction was, this is a theoretical amendment. Moreover, it's a theoretical amendment drafted by someone who may not even be a lawyer, but even if he is a lawyer, doesn't know how things work, doesn't know how to draft and have that happen. And then, lo and behold, I Googled this, and I discovered that it was, as we've just heard, very much not theoretical, and as Ramon's bio will show, drafted by someone with a lot of experience in what he is purporting to revise by constitutional amendment here. I'll go on to say he then says that this is all about liberty and democracy, whereas my reading about it is it's the antithesis of democracy and potentially bad for liberty. So either I'm misunderstanding this, or I need a careful explanation. Now, I understand the impulse behind this, and my comments do not go to that impulse. The impulse is to rein in the regulatory state, both because there should be more liberty and less regulation, and because executive power, as Ramon put it in his comments, laws made by, quote, experts or unelected bureaucrats should be reined in. Again, there are other proposals even at this very conference that in a more, I think, well thought out and moderated way, try and do similar things. But I associate myself with the comments that on one of them, Randy's yesterday, both Sandy and Elliot Spitzer made. Sandy's on the democratic deficit, Spitzer on the problem of uncertainty with this kind of interference with regulation, this kind. And I also have to say, because I'm at the University of Chicago, and I'm contractually bound to use the word efficiency once in every talk, I will say this also strikes me as inefficient. On the sort of high theory level, this is about as undemocratic as you can imagine. We heard about the king in Magna Carta. Well, we don't have a king. We have a president who is still elected. This would delegate the veto power over regulations to 25% of the members of one house, which I am assured by people who know better than I, in the case of the Senate, can represent about 10% of the population. Again, this is really veto power because, as I understand it, as I read this, there is no requirement that there shall be a vote. It's that if 25% of the members of one house communicate their written declaration, and by the way, I don't know how what the limits are and how they communicate it. Can they write it on a cocktail napkin at a White House cocktail party and hand it to the president? Can they put it as a PS in a birthday card to the president? It's not like these other proposals about voting to disapprove. And then again, it requires a majority vote to approve the regulation. Well, that means that If nothing happens, the regulation will not be approved. This basically commandeers the attention of the Congress if they want the regulation to pass. And again, even assuming that the purpose of this is to increase liberty and decrease regulation, it's only proposed regs that this affects, which means that the existing regs stay in effect. And if a proposed reg actually would reduce the regulatory burden, then that too can be vetoed, and we've basically got a freeze frame of existing regulations, which I don't think the proposers of this amendment approve of. There's a lot more I could say, but I'm going to get the hook very soon, so I'll stop.
Very much. So next we'll hear from Will Howell.
Great. So in this age of Donald Trump, and I assure you I'm not a fan of Donald Trump, you can't accuse me of taking the easy way out on this particular assignment. I think that what punched my ticket in being able to come and join you all was a book that I wrote last year with Terry Moe, who is a fellow at the Hoover Institution and who can't be here. It's a book called Relic, how the Constitution undermines effective government, and wait for it, and why we need a more powerful presidency. And so I'm going to argue on behalf of a more powerful presidency, but let me take it in steps and try to bring you from where you're sitting over to here, and I hope I can make some movement in this regard. It's not an argument on behalf of a generically more powerful presidency. It's not about expanding all domains of the American presidency. It's decidedly not about expanding the unilateral powers of the presidency. Rather, it's about enhanced agenda-setting power that we might give the presidency. And so what we have in mind is a system that would build off of an institutional reform about which we have a lot of experience, namely fast-track authority. I'm thinking about using the norms of lawmaking as it relates to fast-track authority to other policy domains. And so this is what would happen under our proposed amendment is that presidents can issue proposals that then have to be voted on, we say within 90 days, on an up or down basis in both chambers of Congress. If they aren't voted on, they automatically become law. But a majority of the House or a majority of the Senate is free to shoot it down. And then we have this October 1 deadline, which is to say, look, the president can't put in a whole bunch of stuff at the end of any particular calendar year and rush things through. Congress is free to ignore those things that come through, and the president would have to reintroduce them in the next year, and the 90-day clock would restart. Okay, so that's what we have in mind. It's about agenda-setting authority. What's the problem that we have in mind? The problem that we have in mind, what is this meant to solve? The problem is not about recalibrating the balance of powers across the various branches of government. That's not what we have in mind. It's not about increasing certain kinds of representation of interests in our politics. That's not quite what we have in mind. What we have in mind is government dysfunction. Put the other way, what we have in mind is what we want to do is think about the kinds of institutional arrangements that will enable the government to effectively solve problems. This was an animating concern of the progressive period, and it's something that we care greatly about. And what we have in mind is the capacity of the government to solve problems ranging from tax reform to climate change to inequality to pollution. There are legitimate debates to be had about what the purposes of government are. Let me stipulate this. What should the government be in the business of doing? What problems should they solve? Legitimate debates to be had, right? What we want to do is to say after we've had those debates as a polity, then we ought to think about the capacity of our political institutions to actually engage in fabricating solutions to problems that are seen as the subject of legitimate public action. And this is where then the presidency and Congress and what the lawmaking process is going to look like comes into play. Because what we have in the main, and we take as as a given, and we could talk about this in question and answer period if you'd like, gross dysfunction. I mean, the utter incapacity of the government to solve problems. So what animates us is less a concern that we have too many rules or too few rules. I don't know how to navigate those particular, adjudicate those kinds of disputes, but rather the capacity of the government to actually solve things in a material way. All right, so as political scientists, how might we get traction on this problem? Our first move is not a move that says, let's go read the case law on a particular domain, but rather to think institutionally about how the incentives and the perspectives of political actors are born of the institutions in which they operate, and how the design of those institutions shape and reshape the kinds of views that elected officials have. And so what I want to draw your attention to is a key distinction between legislators and presidents. If you want to think about what motivates legislators by virtue of being members of Congress, a collective decision-making body that elects people that are expected to represent districts and states for 2 or 6 year periods of time, that there's sort of 3 main considerations that come into play. The first is that members of Congress are parochial in their orientation. They're local in their orientation. When they evaluate policy, they evaluate it first and foremost about the way in which a particular policy is going to affect their constituents back home. More importantly, their organized and powerful interests back home. So they don't think about comprehensive tax reform policy and what that might look like. What they think about is how a change in tax reform policy is going to affect a local concentrated interest in their particular district. They're parochial in their orientation, point number 1. Point number 2, they think about the short term, right? They are, as a number of political scientists have argued, they're running scared. They're paying attention to the next election, which is either as many as 2 or 6 years out. And when they evaluate policy change, they want to think about the implications of policy change in the here and now. They're really fixated on this immediate moment. Point number 2. Point number 3 is born of the first 2, which is that members of Congress pay attention to the pieces and not to the whole. They think, when they evaluate policy, about the one part that disproportionately affects their district or their state. They don't think about the integrity and the coherence of an entire law. That's member by member. They think about their parochial interests, their short-term interests. They pay attention to the pieces and not the whole. And that's in no small part why, when you hand over a complex problem over to Congress, what you get back is a tax code eventually that runs into the thousands of pages. You get a total inability to get traction on long-term reform on something like Social Security, which is years out. When you think about what our favorite case is the Model Cities program, which was meant to provide for opportunities for targeted intervention in select cities to allow for learning. Instead, what you get is a little bit of money distributed across about 150 cities and no learning and no meaningful impact on the problems of urban poverty. That's born of these institutional features of Congress. And so when we think about government dysfunction and the incapacity to solve problems, right, then we ought to be thinking about Congress as it's designed. And presidents are different on all 3 of these regards. Presidents are national in their orientation, not perfectly national. There is the Electoral College, which fixate their attention disproportionately on competitive states. But more so than any other elected official, presidents think about the country as a whole, national in their orientation. To the extent that we think about legislators as being single-minded seekers of re-election, that's what motivates them. Among presidency scholars, if you say, what's the overriding concern of presidents, is that they care about their legacy. They're thinking about the long term. They all want their mug carved out on Mount Rushmore. That's where they're aiming for. Their attention is fixated less on the here and now and more on the longer term. Again, not perfectly, but more so than other elected officials in our government. And then third, to the extent that they care about policy, they pay more attention to policy, the integrity of it as a whole. There's a reason why good governance initiatives regularly emanate from the White House, an effort to introduce some kind of cohesiveness and rationality to the bureaucracy. Reorganization plans are typically born of presidential initiatives. None of this is to say that presidents get it right every time. They don't. None of this is to say that they're omniscient. They aren't. They make real mistakes. But what we do think is that in this pantheon of considerations that are put forward in the efforts of government to solve problems, presidents are excluded as agenda setters, and they shouldn't be. and that what we want to do is to put precedents forward in a way that the members of Congress are not in a position to amend presidential proposals beyond recognition, to fill them up with lard, to allow them to table inconvenient votes because politically they would create problems for them, is to fix legislators squarely on national long-term problems and force them to engage them on terms that are national and long-term. And our best shot of that is by giving the president this kind of agenda-setting power. Last note is I think it satisfies your list, Michael. This is not something that, it's certainly something that recognizes that features of our politics are hardwired. It's politically neutral, right now for me at least, painfully so. It's structural in its orientation, and so it's something that we also have a lot of experience with. The experience, that, to our mind, of fast-track authority has been precisely one that has shifted attention away from local carve-outs and exceptions for particular trade deals and allowed for the liberalization of trade policy, which has been salutary in the main for our country. I'll end there and look forward to the comments.
And Elizabeth Foley will give us some comments.
Okay.
Well, I have to say, Will and I have been going back and forth on this for a couple days, and as soon as I read his proposal, my first reaction was, whoa, that's a new one to me. At first, I thought I might want to curl up in a fetal position and maybe cry a little bit. But then I realized how provocative it was in a really fun way. And whenever you get that feeling where something is sort of causing you intellectual pain, you're at a moment of sort of growth and learning. So I thank him for that. I think it's been really fun for me to turn this diamond over. And I think he's intentionally being provocative for a reason. He and I both had proposals. We were sort of paired together because we're both trying to solve a perceived dysfunction of Congress. We both agree that there's something wrong with that particular institution that needs to be fixed. And I think the way that Will is trying to solve the problem is intriguing because he's trying to essentially sort of light a fire under Congress to get them out of their gridlock and force them essentially to legislate, which is really what they're there to do in the first place. But when the way he's doing it is troubling. To me. It's not just a first mover proposal, which he concedes. It's not just the president's ability to sort of make a proposal to Congress and use his bully pulpit and try to get them to adopt his agenda. The president certainly already has that kind of ability. Some use it effectively and some don't. But basically, this is an amendment which, if it's enacted, would give Congress, I think, 3 choices, maybe only 2, because you can clarify this. I wasn't 100% sure the way it was drafted. But first, Congress could approve the presidential proposal within the 90-day period, in which case it goes into effect, and you specify without amendment. And that's interesting because it's an all-or-nothing scenario. But of course, there'd be nothing once Congress approved the presidential law proposal to then amend that proposal through subsequent regular legislative processes. So it would go in, as a clean slate ab initio, but then it would be subject to later amendment if Congress could muscle the willpower to do so. The second thing that Congress could do is just disapprove it, right, by simple majority. And then the one that I wasn't sure about is whether Congress could just do nothing. I assume if one chamber does nothing, it's disapproved. But if 2 chambers do nothing, it's still nothing to you, and therefore it's disapproval?
No, it's approved. If they do nothing, that counts as a vote for. After 90 days, if the House sits on it, that's the equivalent of voting for it, functionally equivalent to voting for it.
Okay, and that's kind of what I thought. And so 2 out of the 3 of the choices essentially are going to lead to the enactment of a presidential law. Right. So the system is set up so that we're going to have much more unilateral lawmaking by the president. And I think that's troubling, obviously, because this is a situation where one person is going to have both the executive authority, nothing about Article 2 is changing here, as well as a large chunk of what we at least previously thought of as Article 1 territory. And that's going to create, an unstable situation. Every time the president changes, we're going to have much more legislative activity by one person. And whenever you have lawmaking by one person, it tends to be more arbitrary by definition. I know the president is politically accountable, at least in the first term, not so much at all in the second term. So there is some political accountability, at least in the early years. But if the president is not predisposed to cater to the populace and its will, he can do what he wants because he has unilateral lawmaking authority. I think that should all kind of give us pause. And I feel, Professor Howell's pain here. I don't mean to quote Bill Clinton too closely here, but I do feel your pain. I mean, I understand, that you're trying to break the gridlock, and that's a good thing. I know gridlock's not a very pretty thing. It's frustrating, especially for people who have passionate views about certain issues, and they want to get those issues acted upon. But if I have to choose between gridlock and unilateral lawmaking, I'll choose gridlock every time, because frankly, gridlock is not always a bad thing in a society where we do have deep divisions, and we are pluralistic. And I think sometimes gridlock is exactly a reflection of that. It's a reflection of the fact that there are controversial issues, we are deeply divided, and therefore the best answer, perhaps in a republic like ours, is to do absolutely nothing at all. And it doesn't mean that we're not going to have action on these issues. It just means that the action is not going to be at the national level. It's going to be kicked down to the state and local levels, which I think is a good thing, again, because one size does not always fit all on these controversial issues. There is some value in state and local experimentation. So I understand what he's trying to do. He's trying to get Congress to respond. I think that's a good goal. But I don't think forcing Congress to respond at the threat of unilateral presidential lawmaking is the right answer. Thank you.
And now we'll hear from Ruth Wedgwood.
Well, I am in my usual tardy, put it off till tomorrow way, a latecomer in the panel, and so I beg your indulgence if it doesn't quite fit the overall motif of this particular panel. But I have inadvertently, but by lure, become something of an international lawyer over time, as well as an ex-prosecutor, and very interested in changing conceptions of our own law. In particular, we now use the Benthamite term, which is really quite loathsome, of international law, law between nations. But if you go back to the originalist republic, it was considered to be the law of nature in nations, that there really was a belief that there was a normative structure. By the way, this is not about executive power particularly, but never mind. That there was really a normative structure that could be appreciated, taken on board, observed by anybody as a sentient observer who had the ears to hear or eyes to see. And so if you really want to become an originalist on the role of international law in the American Republic, it pays to go back a ways and cast aside, if you will, the Benthamite reductionism of pure positivists and try to recall the ontology of the universe as it was seen back in the late 18th and early 19th century. So I thought I would use that, if you will forgive me, to call attention to some interesting developments that show this kind of positivist versus normative competition, and why Jeremy Bentham and Oliver Wendell Holmes are both evil people. Because they were pure positivists and a kind of tooth and fang and let the best animal win. And it fits a little bit with something as policy, I suppose, with John Ruggie and the whole issue of corporate social responsibility and how and when you should try to integrate that into otherwise up for debate normative systems. So what's happened, I suppose, is in the last little while there has been a greater interest in the personality of corporations, that they are often as powerful as many countries, that they wield their influence through money and threat and seduction on a great many actors on the international scene. And there really has been now a kind of a maturation of how one might act upon that in issues that have to do with corporate social responsibility and therefore how one should properly deploy executive power as well. In particular, there's a new attention to the idea, which was there at the beginning but not much paid attention to, of universal jurisdiction, that you should have an ability to address corporate delicts in many different fora, not just in a particular hard-to-reach place, and ideas of corporate social responsibility, that they really are entities that are so powerful that you should hold them to the same standard of general observation of the law of nature and ethics as anybody else. So what's happened lately, the issue is what do you do about instances where you think corporations are behaving badly? And there are some, whether you're a business lawyer or a philosopher, some developments that are worthy of note. One is Brussels Regulation Number 100, well named, from '01. And what it says is that the law of nature and nations, who uses that term anymore? Not Chicago might, actually.
I don't.
That the law of nature and nations is enforceable in any European corporate domicile. So if Nestle's chocolate is in Switzerland and doing bad shit, pardon my French, edit that out, please, in a particular country in Africa, that you could actually sue the company in its corporate domicile, and therefore have a chance of actually having decent adjudication and perhaps enforcement. So you don't need to play, you no longer need to play tag jurisdiction to find a place where you can sue a corporation for misbehavior abroad. You can actually go in Europe to the corporate domicile and sue them for things they might have done that were not particularly attractive in Africa, South America, wherever. And that, I think, is worthy of note, that in fact the law that might formerly have been seen as almost out of reach is now highly enforceable in European courts. Second is the kind of revival of the Alien Tort Statute. And Jose Cabranes is one of my best friends, and so is his wife, Kate Stith. But Jose has this entirely wrong. Jose has been the kind of voice of stubbornness and obduracy in the Second Circuit, trying to keep the Alien Tort Statute, 28 U.S.C. 1350, dating from the First Judiciary Act, to keep it from really having teeth. And when you go back to the founding daddies, they actually were normatively very cool guys. So that reads, district courts shall have original jurisdiction of any civil action by an alien for a tort only, committed in violation of the law of nations or a treaty of the United States. And that has become something quite useful if you're thinking about ways to give remedy to people who have not been well treated in around the world, frankly. If you have a corporation that would have enough attachment to the U.S. that they could properly be sued here, basically the ATS now gives you this venerable structure in which to plead that the delict that was committed against workers or women or corporate pollution is a tort in violation of the law of nations. There has been a great fight about this lately. I think probably the Chicago School is inclined not to like this just because you have a much more tooth and fang kind of best person survives.
You got to come to your Chicago. It's changed.
But what is a problem, oddly enough, is almost generational. Older law professors, older lawyers, didn't ever really take international law. And if they took it, it was in this reductionist, positivist way. And they didn't realize that this, in its root, 28 U.S.C. 1350, was an open invitation to mix law and norms, or operational law and normative structures. So that, in fact, the ATS is, I think, a very attractive venue in which to worry about how the U.S. behaves and allows its corporations and its subsidiaries to behave abroad, and whether it's chopping. What I think first got my real attention in this whole area, if you haven't seen it, you got to see the movie, King Leopold in the Congo, when he was harvesting rubber. If you didn't make your quota, he would do a diagonal chop and chop a hand and a foot. So you could neither walk nor sit nor reach. And this enormous numbers of people. And you think the slave trade was bad, being double chopped was worse because he starved to death. So I think we tend to overlook the recentness of the colonial past in which people were treated really quite atrociously. And most, in the olden days, meaning 20 years ago, most American judges and lawyers didn't take international law. They didn't have a sense of where and how it can be used. So what's lately happened is that the Kiobel case in which my very good friend, Kate Stith's husband, Judge Cabranes, took a very narrow rule of what it might mean, even though he had been a protege of Cy Vance, who had a very broad-minded view of the world, and basically said that it could not be used in the ways that one wished, that it really, the law of nations was really not a cognizable source of law. The Supremes have now amended that, and the law of nature and nations, if you call it international law, is fully acceptable as a source of law. And I think that also the Second Circuit, in Jose's eyes, was going to be grandiose if it tried to suppose it could govern the entire globe. But in fact, whether it's by nexus or corporate relationships, there probably is proper jurisdiction for most of this. The hot news off the teletype machine lately, the Supremes have just granted certiorari in a case called Jesner versus Arab Bank, and that will determine whether corporations can be defendants in an ATS case for torts against the law of nations. So this is very timely stuff. And there, if you like the more lapidary views of the 19th century, which I tend to, your time has come again. So the prior holding in Kyobo, the corporations were simply not amenable to suit under the law of the circuit, may well be overcome by the, I think, rather broader view oftentimes of people like John Roberts. Finally, since I'm giving no more time, let me just put on your dance card also. Do look at Brussels Regulation Number 100, which is from 12/2001. And Brussels Regulation 100 basically says that the law of nations is enforceable in any European corporate domicile as to conduct anywhere in the world. So it cements and reinforces the idea that, yes, indeed, guys and gals, there is such a thing as universal jurisdiction. It's not some crazy invention of Ralph Nader. It really had venerable intellectual and cultural roots in a much earlier time of law. It keeps you from having to play tag jurisdiction to try to find some kind of corporate asset in the place where you could sue, and allows you basically to go to Europe and get justice for your clients. And finally, I will just note in last closing moment, this is really not a new idea in American jurisprudence. If you look hard enough, one of my favorite cases that nobody reads anymore is Holmes against Jennison from 1840. And this involves an early form of universal jurisdiction. A transient criminal in Vermont could not be extradited to Canada at the time because we had no treaty which was applicable for Canada. So the state of Vermont bodaciously decided it would use universal jurisdiction, that it had no duty to allow criminals to dwell within it, that it could therefore adjudicate a criminal act that occurred anywhere on the globe, as long as the malefactor was within its reach. And I'll just one last quote. It states, any state may, if they think proper, in order to deter offenders in other countries from coming among them, make crimes committed elsewhere punishable in their own courts if the guilty party be found within their jurisdiction. In all of his cases, the state acts with a view to its own safety and is in no degree connected with the foreign government in which the crime was committed. In other words, the idea that there should be some effective justice, even as to acts that occurred elsewhere, so long as the malefactor seeks to be within your comity, your community and the comity of your laws, is one that has very, very old roots in the early republic and is therefore something that should not be seen as overreaching, and therefore, in my view, would give a strong basis for concluding that U.S. courts could reach malefactions abroad that the local governments there would choose not to remedy.
And now we'll hear from Laura Donahue.
So Professor Wedgwood would like to strengthen the role of international law in the United States. I respectfully disagree. I disagree. In support of her argument, Professor Wedgwood raises this Second Circuit opinion in Howell versus Dutch Petroleum. The court considered then whether the ATCA, the Alien Tort Claims Act, presumptively applies extraterritorially. It concluded that it did not. In that, under the law, as you noted, Professor Wedgwood, it relates to all causes where an alien sues for a tort in violation of the law of nations or of the United States. The basic idea is universal jurisdiction over international law. Now, under Sosa versus Alvarez Machain, this is a case from 2004 that the Supreme Court heard, the international legal norms that qualify as a cause of action must be, quote, specific, universal, and obligatory. Now, these are some examples of this that the Second Circuit gave in a different case where genocide, war, crimes against humanity, and torture. Now, in Sosa, the brief detention of an individual and torture of that individual, it was insufficient for the Supreme Court to find that it qualified underneath that statute. In Howell, in contrast, you had serious crimes along the lines of what the Second Circuit suggested were sufficient. Royal Dutch Shell compelled its subsidiary to cooperate with the Nigerian government to crush peaceful resistance to oil development. According to the district court, customary international law does not define aiding and abetting, property destruction, forced exile, extrajudicial killing, and violations of the right to life, liberty, security, and association. Now, when the case went to the Second Circuit, the court held that corporations can't be held liable for violations of customary international law. The Supreme Court, when they heard the case, actually Kathleen Sullivan, Professor McConnell's precursor here at the Constitutional Law Center, I actually was here with Kathleen Sullivan for a number of years. She argued the case twice. The first time in February of 2012, the second time in October of 2012, against Don Verrilli, the Solicitor General at that point. The court had asked for further briefing on a specific question, specifically whether and under what circumstances the Alien Tort Statute allows the courts to recognize a cause of action for violations of the laws of nation occurring within the territory of a sovereign other than the United States. Now, the court 5-4 said that the claims under the ATCA have a presumption against extraterritoriality. It noted the danger that the courts would be interfering in U.S. foreign policy. The court got it right in that case. In reaching this conclusion, the court did two things. First, and most importantly, it dodged a question that's really at the heart of Professor Wedgwood's suggested amendment to the Constitution. Secondly, it also embraced a centuries-old rationale behind the law of nations. So first, the question, what do we mean by law of nations? Well, the answer is not as clear as one might think, and that is why I would reject any amendment more closely tying the U.S. Constitution to international law. In 1765, in his commentaries on the laws of England, Sir William Blackstone offered the following definition. The law of nations is a system of rules deducible by natural reason and established by universal consent among the civilized inhabitants of the world in order to decide all disputes, to regulate all ceremonies and civilities, and to ensure observance frequently occur between two or more independent states and the individuals belonging to each. So for Blackstone, the law was founded upon this principle that different nations ought in times of peace to do one to one another all the good they can, and in times of war as little harm as possible. The law of nations was essentially an agreement amongst equals. He pointed to disputes related to prizes, shipwrecks, hostages, but he had a fundamental insight, namely that offenses against the law of nations can rarely, this is a quote, rarely be the criminal law of any particular state. For offenses against this law are principally incident to whole states or nations, in which case recourse can only be had to war. So where individuals of any state violate the laws of nations, it's in the interest and the duty of the government under which they live to prosecute that violation. Only in that way could you maintain peace between countries. So either countries hold their citizens accountable, or they risk associating themselves with the wrongdoers and then exposing their people to the liabilities of war. Blackstone went on to outline the principal offenses against the law of nation, the violation of safe conducts, the infringement of rights of ambassadors, and privacy. Under Blackstone's rationale, the court got it right in Kayable. Now, Professor Wedgwood appears to be more optimistic that the court granted cert in Gessner and Arab Bank, that we should see more and not less respect for the law of nations. I'm not so sure. In Gessner, we have several aliens who were injured, kidnapped, or killed in terrorist attacks against Israeli citizens overseas. The surviving aliens and friends of those who died accused Arab Bank, which was headquartered in Jordan, of financing and facilitating those terrorist organizations, and Arab Bank moved to dismiss under Kayable. Now, the district court said that because the Supreme Court had not yet addressed the question of corporate liability, the appellate holding, no corporate liability under the ATCSA, is controlling precedent, and it dismissed the ATCA claims. The appellate court essentially held course. The Supreme Court is now expected to consider whether corporate liability exists or stands. Now, looked at in terms of Blackstone, my own thought is that corporate liability is not necessarily precluded. Corporations, like individuals, can place themselves in a state of nature. For Cook, in his institutes, this was hostis humani generis. This is you've put yourself as an enemy to mankind, much as pirates would have. However, we have in this situation a bank headquartered not in the US, but in Jordan, and under one reading of Blackstone, it is incumbent upon Jordan to hold them accountable under the law of nations as it is traditionally understood. The alternative would be to declare war on Jordan. Thank you.
We have lots of time for questions, and I think Mark Storsley is up.
Great, thank you. So my question is for Roman and for Will. Reading each of your proposals independently, I think I don't like either one. I like Roman's proposal in the sense that I also have worries about the administrative state run out of control, but I worry about a lot of regulations that we actually do depend on, and I worry about the gridlock problem that I think is motivating Will's proposal and the way it might cripple our government to do anything, which right now, unfortunately, a lot of which we can only do through executive action. On Will's proposal, I guess my worry is something like that now we've augmented presidential power, now we have an exceedingly powerful administrative state, and now we have a president who's also effectively able to set the table for Congress and sort of do half of Congress's job for them too, and I worry about that. But then I started thinking, I actually like both of these proposals together. If both of these proposals were one constitutional amendment, I think I would vote for it. And one reason that occurs to me is because with Roman's proposal, what you get is a basically cutting off the spigot of sort of regulatory authority as the basis for doing things, right? Giving Congress a very strong stick to just delete administrative action they don't like. But you also solve Will's gridlock problem because you give the president tons of power to push all the things he's currently pushing through regulation, through the legislative process, right, through the sort of traditional constitutional processes that we already have, and solve the legitimacy problem with the regulatory state. So my question is just, how do you guys see your amendments in relation to each other? If the other person's amendment were enacted alongside yours, would you consider that a victory and sort of furthering what you're trying to do, or would you consider that a defeat and something, to be lamented, something that ruined your amendment because Roman's amendment was also passed?
If Roman only gets his way and I don't get mine, it's a loss. That's how I see it.
I figured you'd see it that way, for sure.
Right, but with cause. It's that there are problems that the president is attempting to address, but he can only address in a very piecemeal way. The idea that these unilateral directives that presidents are issuing are cheap substitutes for systematic, serious, comprehensive reform that can only happen legislatively. My sense is that the spigot won't be turned off, but it will be shut down a bit organically if you just do the proposal that we're suggesting, if only because the courts may be willing to step forward and to say, look, you don't get to do all this stuff unilaterally because you could have introduced that stuff and you decided not to, or you did introduce those things and Congress shut it down. And so we're going to think about the space that we're going to afford for you to engage in this administrative lawmaking in more narrow, restricted terms. So it may happen organically, But if you wanted to do it more formalistically as well, I think that would be fine. Or in many ways, the proposal that we're trying to put forward is to say we want to enliven the legislative process and not just attend to the problem of gridlock. It's not just about passing more laws. It's about shifting the terms under which we evaluate policy and fixing those terms to a greater extent than which they are right now on long-term national considerations, where, right, we think about Trump, the one-page tax policy. What would happen if he just handed that over to Congress, and it's going to turn very quickly into hundreds and hundreds of pages of all the carve-outs and exceptions are put into place, which is exactly the story of the aftermath of the 1986 tax reform policy, which simplified policies tremendously, and then we see all the complications that follow. So it's not just a story about gridlock, it's about how we think about cohesive national long-term policy and advance those sorts of considerations.
So my reaction is that the country was founded on the idea of consent of the governed. And so conceptually, we're coming from two different places. Bill, or should I call you William?
Or Will. You go Will or William, those are
William
your choices.
Tell, okay, so the concept here is that the president, with the support of a blocking percentage of one house, can basically impose law without the consent of the governed. And I think that's problematic from a number of points of view. I think that what happens in the political process is sometimes unpredictable, and I don't think one can rule out any sort of compromise that members of Congress, because in my view, members of Congress are going to have to vote for this by 2/3. If in some way members of Congress decide that there is a way to combine some aspect of our proposal and something else in a way that gets 2/3 of the votes, I think that's the way the legislative process works. I think what's interesting about William's idea is if you take the base closing commission idea, the base closing commission idea was force Congress to vote up or down. And if you modified William's proposal to say the president on a certain number of occasions could force Congress to vote on a proposal that the president had, and up or down, and you preserve the principle that laws still have to be approved by a majority vote, but that the president could cut through the gridlock and say, I'm going to demand that you vote on this, and if you want to vote me down, fine, you'll be accountable to your constituents, and so will I. I think that idea has a lot more appeal to it than the idea of allowing the president to issue an edict that only Congress can block. But I think we're at a point now where the country really has to make a decision. Do we want to preserve the principle that the rules of governance are approved by have the consent of the governed or not? And to your question of gridlock, Congress has successfully passed an appropriations bill in almost all of the 225 years. It's been messy, it's been ugly, it hasn't worked right, but that's democracy. And I believe that in the end, the experience of Russ Feingold on McCain-Feingold, the experience in the Patriot Act, which I don't agree with all of it, but Congress has demonstrated that when the public wants something, it can respond. And again, if you think 90,000 regulations are not nearly enough and we need many, many more, then you're not going to like my proposal. If you think that we might be able to get along with a few less, then maybe you'll give it some consideration.
Two quick questions for Will. Will, your proposal talks about proposals not being voted upon automatically becoming law. And what was unclear to me is what you mean by not voted upon. So if one chamber votes to disapprove of a presidential proposal, but the other chamber does nothing, I'm not sure. I mean, in one sense, it has been voted upon, but not by both chambers. And so I wasn't sure what your proposal meant in that situation. And the second question has to do with a clever president who says, I'm going to give you 10,000 proposals. You're not going to be able to act on them all, and I will get, I'll be able to pass whatever I want to because you're just not going to be able to act upon them all.
Great questions. So there's some ambiguity in the language, which we need to clear up. Our own thinking is that if one chamber votes it down, it's done. So if the other, you've got to, what we want to rule out is both chambers, one chamber voting it up and the other one saying, I'm just not going to touch it and let it die that way. If one chamber votes it up and the other one doesn't vote, then it gets through. But all it takes is for one to take a positive action and vote something down, and then that law is finished. And in that way, I disagree that by your characterization, Professor Rowley, that it's unilateral lawmaking. It's that Congress has every power to step in and to vote the thing down, and they can do so in short order. I agree, there is a concern that what the president would do is they'd game the system and just load up the whole legislative calendar with their own proposals. There's nothing that then ostensibly would keep Congress by responding in kind and just simply voting everything down in one fell swoop. They'd be free to do that. Also, the October 1 deadline was our effort to try to get at this problem, though. You may want to, right there, there's going to be a portion of the calendar where the president can't do this. Now, maybe you don't want to say it's October 1. Maybe we want to back it up and give more time to Congress to be able to legislate as it so chooses, and fair enough. One way in which some other presidential democracies respond to try to put limits on it is to say that the president can only do this for a certain number of laws. Right? They can do it. So Mexico, you get 3 shots each calendar year, president, and that's it. That creates other kinds of perversities, though, because it encourages the president to load up any one law with all kinds of initiatives. So our best shot at trying to deal with this problem is with the October 1 deadline. One that is, I don't see this as an edict at all. Again, these are presidential proposals. That's all it is. So if what you want to do is to say that what the president can do is to point to something that's been introduced organically within Congress and say, now you have to vote on that one up or down, well, then that just, all then the president would have to do is sort of find a happy person within there, right, a co-partisan within there to introduce his proposal, and then we're in the world that we're imagining. But this puts it all front and center. These are presidential proposals, and again, Congress is free to vote it down if they so choose, and carry on in legislating in their own due course.
Yes, I have a question for Mr. Buhler. I was hoping that you could just talk a little bit more about what you feel is at stake with the amendment that you have, because you use very emotional rhetoric when you talk about the amendment, things like edicts, references to the foundations of the Republic, 90,000 regulations, these kinds of things. But it seems like, of course, there are a lot of ways in which administrative regulations are not actually edicts. The respondent mentioned that the president is elected. Agencies can only act insofar as legislative authority is delegated to them by the legislature. So it just seems that instead of, and then there are principles of administrative law that are used to make sure that regulations comport with some notion of procedural due process. And I just think that, just to give one example of I guess what I think is at stake with some of these regulations, there were 10% more highway fatalities in 2015 than 2014. And if we think that the federal government should be involved in passing regulations to address whatever the cause of that problem was, I think that that's more the role of government exercising delegated legislative authority than a vague notion of what the Republic stands for.
So I think you make 2 points. One is there's clearly a role for federal regulation in protecting health and safety and the environment and consumers. And that's, that's the function both of law and of administrative law. But what we've seen in the last few years is that the relationship between the delegation that's been authorized by Congress and the power that has been exercised by agencies has become increasingly tenuous. That when you can go and take a law that was passed 50 years ago and turn that law into a new regulation which has almost nothing to do with what Congress intended when it passed the law. There is, of course, the courts have required that there be some reasonable connection between the regulation and the words in the original law. But there is such an enormous grant of power in that there's so much flexibility there that in practice, regulators can rewrite the law. Now, They can't rewrite the law in a way that has no relationship to the original words, but they can rewrite the law in very, very, very substantial and fundamental ways. And I think the point, the reason that I relate this to the Republic, is if the president can completely transform the meaning of Congress, any law that's ever been passed, we are not safe, because the president can tailor the regulations which essentially rewrite the law to punish his or her friends, reward his or her enemies, and in practice, the president is in fact making law without our consent. And so I think there's a middle ground where regulations that are genuinely needed for health and safety and consumer protection, I think those regulations will continue to happen. And I think there are an enormous number of regulations that are needed, or at least considered very useful for the operation of government. And I think those will happen. And members of Congress who try to gum up the works and stop government are going to suffer the same fate as some people who thought that they could shut down the government because it wasn't, the appropriations bills weren't to their liking. The public didn't like that, didn't reward that behavior. And I think obstructive behavior is not going to be rewarded if regulations are to be approved. But what we are doing here is restoring the legislative link and the approval of the public in the law. We're not stopping regulation. We're making sure that it has the consent of the governed. And I recognize that there's some people who would like more regulation and less accountability because it's more efficient. You know, some people want the trains to run on time, and they're willing to give up approval of the legislature to get that happen. But I don't think that's the right solution for the future of the country.
Yeah, this is a question for Professor Wedgwood. Congress has the power to define and punish offenses against the law of nations. And I think the framers' idea in giving Congress this power was twofold. The first was that rather than have a wholesale incorporation of customary international law into our system, that Congress would decide which norms of international law would be appropriately enforced through the courts, and which norms would be more appropriately enforced through diplomatic action. And secondly, the second concern that's reflected in this, and is actually reflected in the actual convention debates on this provision, is that international law of nations, customary international law is itself often difficult to determine, it being a customary unwritten set of practices. And so some definition from the legislature in order to give guidance to courts as to what international rules, in fact, were being adopted. So that seems like the system that was that the framers specifically thought through in terms of how international law, customary international law, would interact with our constitutional system. And so my question is, why is that inadequate? Why can't Congress make those determinations? Now, you might say that, in fact, the Alien Tort Statute does make those determinations, but the Alien Tort Statute, I think, is notoriously cryptic and subject to multiple interpretations. And in any event, the Alien Tort Statute, as the Supreme Court has said, is simply jurisdictional. It does not provide any cause of action, but in the court's view, is left to the courts to think it through. But perhaps it is the appropriate role of Congress to make these determinations, and if the court has got the Alien Tort Statute, in any event, if the Alien Tort Statute, the court has got the Alien Tort Statute wrong, Congress can fix that problem. And it's not the case that Congress is entirely blind to international human rights, because Congress, the modern Congress, did enact the Torture Victim Protection Act, which reflects concern over a number of these issues and provides a cause of action for international human rights against specified defendants and for specified malfeasance, torture and extrajudicial killing, precisely in the way that the framers seem to envision Congress acting to pick out which are the appropriate international crimes to redress through our courts and to give definitions. So my question is, what's broken about this system? Why shouldn't we just rely on Congress to decide whether the kinds of, and to what extent, the international corporate malfeasance that you're concerned about and that I'm also concerned about are things that are properly addressed through U.S. courts in exactly the same way that the European Union, the legislative body of the European Union, decided that particular crimes, and not others, would be redressed in the European Union.
Well, partly, I guess this may be a sensibility that's informed by what I observed when I was a prosecutor of the rather well-intended but parochial view of local judges, of Judge Sprizzo, for example, or the Bhopal case, where the if you're a busy district court judge and you have a lot of cases backing up and they're armed robberies and bank fraud and you've just got to get through your business, it doesn't strike you that you're the person that God anointed to reach out and take care of the poor or the bereft of Bhopal or Africa. But I do think the Founding Fathers and Mothers, to their credit, had a rather more expansive view that America, dare I sound sentimental and metaphysically confused, had this kind of redemptive role in the world. And that setting an example by occasionally taking on a case which showed a troubling delict in violation of the law of nature, which we don't believe in anymore, but I do, and nations, is something that has didactic effect on other people. Otherwise, just like there's Little England, we become Little America, where we say we're only concerned about our own welfare and profiteering or profit, and the rest of the world is not ours to be concerned about. Whereas if you look at the view of the Founding Fathers and Mothers, they really did see the American example as something that would shine a light and set aglow a normative commitment that perhaps at that point the more cynical colonial powers eschewed. By the way, I misspoke. It's Brussels number 1, not 100, so forgive me. But really, there's a shining light. And when the Statue of Liberty is put in New York Harbor, it's not just to welcome immigrants, it's to try to make the point that there really is a self-conception that is redemptive. So I don't see this as sentimental. I do see it as an attempt to overcome the self-dealing failure of a great many countries to act upon the delicts of corporations that are formed in their own venue. It's something that will be done sparingly. But if you look at what happened even in the Paul case, I'll just take this as an example. Again, Judge Sprizzo was a great judge. I loved him. But he didn't want to be involved in this with 15,000 injured Indians. There really is a kind of a homeboy solipsism in a lot of federal district judges who have to get through their work and may not give sufficient credit to the rather expansive view of the American moral vocation that I would take, and that I think was in fact characteristic of the views of the 1770s, 80s, and 90s. This is not ahistorical, it's historical, a view of America's role in the world, pre-colonialism, and adapted to new facts in which the European powers were often the worst actors because they had direct profiteering. So it frightens judges, because where would you stop? And you can have all kinds of ways of truncating and choosing cases and dismissing for failure to plead with particularity. But it is the case that if we don't look at this seriously, we are behind Europe, because they are. Because Brussels Regulation number 1 really is this extraordinary invitation to bring cases to court in Europe if you need to.
So we have about 5 minutes and 3 questioners, so no multi-part questions.
Okay, one part. Do you approve 2 amendments to your amendment of the president as agenda setter? 1, including significant regulations, 2, straddling the election for the approval, so that a person running for Congress has to say how he'll vote, he or she, in the election, rather than having it within that short period where they've already been elected.
I want to think about both, but I like the spirit of both questions. I mean, we might want to think about issues of timing. We might want to think about issues of scope. How do we think about regulations as part of it? The real thrust is to try to put the president front and center as an agenda setter and force a congressional response. I want to stand firmly by that. Then how do we provide sort of the minutia, those sorts of adjustments? Yeah, open to it.
This is also a question for Will Howell, and I just wanted to invite you to say just a little bit more about the relationship between the proposal and existing House and Senate rules about bringing legislation about. Before I had focused on the silence issue, I had thought that when we say agenda setting, in the course that you're actually putting something on the legislative calendar that has to be voted. But if silence is an option, that seems to put a lot of, under existing rules, that seems to put an awful lot of power in the hands of the majority leader and the Speaker of the House, where the current status quo would be without a vote, there's no law. But given that it's extremely difficult for the minority party to get a vote on something, that this is quite radical. And I'm not sure if maybe that's the intention, but it does. Are you contemplating some change in the procedures by which one gets a vote to the House floor or the Senate floor?
I need to think more about that. I think it's a good question. We purposefully wanted to rule out the possibility for legislators to simply table a proposal put forward by the president, precisely because they have every incentive, right, to ignore tough votes, sometimes for political reasons, oftentimes for political reasons, and also because what they're going to want to do is load it up with lots of, to our mind, junk. It's stuff that has very little to do with the larger problem that's trying to be attended to. How exactly mechanistically that will work when the president issues it, right? What we have in mind is there would be a formal proposal put forward, then there's going to start a 90-day clock, and there has to be an official vote on the floor, and a majority voting in favor of it is going to be what it takes in order for it to pass through. If more is involved, we should talk.
This is also for William. The nature of these structural proposals is that they have second-order consequences that they rattle through the system, right? And I want you to hum a few more bars. I mean, one thing I can immediately think of, party platforms will probably be much more important in presidential elections. Another thing I can think of, I may be wrong about all of this, but another thing that comes to mind is that the party leadership will be much more important and even more powerful than we've already made it over the past years. And there may be other sort of consequences, good or bad, that ensue in the wake of this. And I would like you to say a few more, even if it's pure speculation. Say a bit more.
Let me point to two. I think this is spot on. This is exactly what we should be worrying about when we think about structural reforms. It isn't just sort of the immediate direct effect, is it how does it percolate through the system? Two more. I suggested earlier that one thing that may happen from the judiciary is that they may no longer be willing to read into congressional silence, tacit consent, for presidential initiatives. They may say, no, you can force Congress to articulate a view on a policy issue, and if you don't exercise that option, we're going to foreclose the opportunity for you to exercise these unilateral powers, just as I think there will be fewer incentives for presidents to exercise these unilateral powers. They do it, oftentimes, precisely because they can't get a vote in Congress. If they could get such a vote, there would be fewer incentives. It's not that the incentives would go away entirely, but there would be fewer incentives to exercise these options. I also think that there may be electoral implications. How do we want to think about this? Part of the reason why agenda setting matters a lot when it's in the hands of the majority leader is the majority leader can protect it's almost always his, sometimes her, flock from having to cast hard votes. What happens then when they're forced to cast hard votes? That then may lead to changes in the base level of support that the constituents are going to be willing to give their representatives, which may disrupt the party's ability to exercise discipline within its ranks. So there may be electoral implications as well. I think this may play out in a number of ways. Let me end on this last one, which is to say, we're trying to push off from a set of reforms that have already been put in place. The 1921 Budget Act, right, where it's the president who now initiates the budget process, and the fast-track authority. And this is a much more robust version of both those kinds of agenda-setting powers, but it's trying to simultaneously build off of past experience while also recognizing that there may be some downstream consequences that turn out to be pernicious. And then the right thing to do is to make a subsequent adjustment. we should think these things through as best we can, but with a due humility that we may have blind spots. And if we do have blind spots, subsequently an additional correction may be in order.
Okay, I think we have about 10 minutes until the next panel.